Good morning. I want to start by saying what a pleasure it's been for me to have my son David working with us, and I always learn something from him in these presentations, and I hope you have too. But he also was definitely born into this business, and I was sitting there thinking about a time many years ago when he was about 5 or 6 years old, and after a hard week at work, we were all out relaxing by the pool, and the phone rings, and little David runs in to answer it. And he comes back out and says, "Dad, it's for you. I think it's a broker." So that was his part of his indoctrination into the business. All right, but what I'm doing today is comparing different types, different forms of registration, state, Coast Guard, and foreign. Starting off with state, I think as most of you know, there's state titling and registration varies state to state. You have what are called title states, you have what are called registration states, and you have title and registration states. And what I mean by that, in some states they issue a title to the boat and you're not required to register it. Other states, Delaware being the predominant example, they issue only a registration. You just get a little card. Florida is a dual state. We have titles and we also have registrations, which are shown up there. The principal benefits, they're simple, they're inexpensive, and they're generally available for yachts of all size. So for instance, if we've got a tender on a large yacht, the yacht may be registered federally with the Coast Guard or under a foreign flag, but the tender will be generally registered with a state. The reason you register them at all is that if you're doing anything other than ship-to-shore business with a tender, in most states it has to be titled or registered somewhere. You do have annual fees, but you have that in any case with other forms of registry. State sales and use tax. It's not that because you're state registered or state titled, you become liable for state sales and use tax. It just is that in most states, one of the conditions to titling or registering your boat is that you show that either tax has been paid or that the boat is exempt. So you have to make a declaration. You cannot use a boat in certain trades. You can a state registered boat may only be used for recreational purposes. Under U.S. law, recreational use is defined to include a bareboat charter, so technically you could charter it, albeit on a bareboat basis, but you could never use it to carry passengers for hire. You wouldn't have the right to, under any circumstances, to pick up passengers in one port and drop them off in another. You cannot obtain a preferred ship mortgage against a state registered vessel, although more on that later. And therefore, in a title state, the way you put a lien on a boat is typically by its placed, the fact of the claim, the fact of the lien is on the title itself. And in registration states, the best you can do is record a UCC financing statement, UCC-1, to show that you have a lien. And banks generally find, for obvious reasons, those forms of perfecting their rights to be less beneficial, less protective than under a preferred ship mortgage with a federally documented boat. Less protection when traveling outside the U.S. What that really means is that a state-registered vessel is not a U.S. flag vessel, and therefore if there are conventions or local port-state rules that provide benefits or rights to vessels flagged in another jurisdiction, unless the definition of that is broad enough, it wouldn't necessarily then include a state-registered boat. Often we see state registration or titling used by non-citizens, non-U.S. citizens, because as I'll explain in a moment, they're not eligible for U.S. documentation. And we've seen that quite often. The problem with that, which doesn't always surface, is that Customs and Border Protection, CBP, considers a foreign-owned, a boat owned by a non-citizen to be a foreign vessel, even though it's registered with a U.S. state. On the other hand, it is not a foreign flag vessel. So by virtue of the fact that it's a foreign vessel, their view is if you're moving it from point to point, you can't obtain a cruising license allowing you to do so. You can only obtain permission to proceed. And so if you had a foreign-owned boat, state-registered foreign-owned boat, if CBP or Coast Guard, Marine Patrol, anyone noted it and reported it, then they could restrict you to traveling solely under permits to proceed from CBP. Next, U.S. Coast Guard documentation. I think, as you all know, all U.S. Coast Guard documentation is handled out of the National Vessel Documentation Center in Falling Waters, West Virginia. When I started practicing, the documentation offices were located in various ports around the country. I mean, we had one in West Palm Beach. There was even one in Key West. But when the NVDC was created, they consolidated everything in West Virginia. And the reason West Virginia was selected is that Senator Byrd at that time had a lot of pull in Congress, and he wanted it in his home state. Since you're then a flagged vessel, you're a vessel of the United States, it is easier to use the boat in foreign waters. Again, as a flagged boat, you're entitled to whatever benefits and protections are given to vessels flagged in foreign countries in different port states around the world. You also can obtain a preferred ship mortgage, which a bank is going to want. But one thing I should have mentioned before, that one of the principal benefits of a preferred ship mortgage is that preferred ship mortgage is superior. I mean, it'll prime any subsequent maritime lien except for certain classes of preferred liens, and therefore the bank doesn't have to worry about, say, you're in a shipyard and you don't pay your bill and the shipyard asserts a lien. If you have a preferred ship mortgage and the lien was incurred after the perfection of the preferred ships mortgage, then the preferred ships mortgage would prime the subsequent claim. That is not the case with a state-registered vessel or state-titled vessel or registered vessel on which the bank merely has a lien on the title or a UCC filing of record. It also will enable certain yachts to engage in coastwise trade, meaning carrying passengers from port to port. It's not enough, though, that you merely be U.S. documented to have that right. You have to be a U.S.-built boat, although there's an exception to that. And the boat can never have gone foreign, been registered foreign, if it's over 200 gross tons. If it's less than 200 gross tons, when a boat comes back from having been registered foreign, it has an automatic waiver of, or a restoration, I should say, of its former coastwise rights. Endorsement to charter in U.S. waters. As I said before, in terms of chartering in U.S. waters, you can, certain yachts are eligible to do that. Otherwise, if you have a U.S. flag vessel that doesn't otherwise qualify for coastwise use, you can still charter on a recreational basis, which means bareboat, and you can charter under a so-called registry endorsement, which pertains to charters that take place either between a port in the United States and a foreign port or between foreign ports. But if you are chartering outside the U.S., under those circumstances, under the registry endorsement, where you're carrying passengers for hire, the boat has to have a load line and load line certificate. And U.S. flag vessels, for reasons I think that were discussed earlier in terms of the difficulties in building a boat that meets commercial requirements, load lines just aren't going to happen. I mean, I think it has been done recently. I know one case in which that was done, but ironically, though, they certified the boat, they gave it a certificate of inspection under Coast Guard regulations. They said, we're giving this to you, but you cannot use the boat for carrying passengers for hire, for coastwise use. So you're basically restricted from that. Disadvantages. Again, U.S. documentation is available only for U.S. citizens, with an individual that's obvious in terms of who's a citizen and who's not a citizen. With a corporation, not so clear. And actually, whether you're considered a citizen as a corporation depends on how you intend to use your boat. And for a recreational use, a bareboat use, you can structure it such that a foreign owner is able to have a U.S. documented vessel. And the reason for that is that with respect to a boat that's being used recreationally, the requirement with respect to a corporate owner is that the president or CEO, I mean the chief managing officer by whatever description, has to be a citizen, and no more than a minority of a quorum of directors can be non-citizens. That sounds complicated, a minority of a quorum of directors, but the idea being that you could never have a quorum of directors that are entitled to meet and take action for the corporation if a majority of those present could be non-citizens. And if you have a client then who wants to set up this kind of a structure, and a non-citizen client, he'll just have to have a single individual who's a U.S. citizen that is willing, and he's willing to have, and who himself is willing to serve as the president or CEO and, say, sole director. You can have more than one, but U.S. citizen, but it's certainly easier with one alone. U.S. documentation is restricted to boats that are over 5 net tons. Well, what does that mean? I mean, the net tonnage formula is a bit complicated, but typically boats of, it's called around 28 feet, more or less, are up to that point not 5 net tons, over above, but that is something that would have to be proven. In terms of the upper limit, and I think this was something that was mentioned earlier, the practical limit is 300 gross tons, and again, tonnage in this context is a measurement of volume, not weight. So when a boat reaches 300 gross tons depends, well, both on its length, but even more on its configuration. But you'll typically see boats, say, above 120 feet, more or less, exceeding that figure, although they can be less if they have significant interior volume. And the reason there's this practical upward limit goes back to what was said earlier, and if you're over 300 gross tons, you're considered to be a seagoing motor vessel. And actually, this doesn't matter whether it's U.S. documented or state registered. You're considered to be a seagoing motor vessel. And once you're considered to be a seagoing motor vessel, you have to comply with the Coast Guard's inspection requirements under subchapter I for miscellaneous boats, which were not enacted with yachts in mind. So you're really meeting true cargo ship requirements, and therefore you're basically forced out. So 300 gross tons is the practical limit. Not necessarily exempt from registration. In Florida, for example, if a boat that is a documented vessel that's registered in another state comes into Florida and stays in the state for more than 90 consecutive days, it's required to get a Florida registration. This is what I alluded to earlier, the Vessel Identification System, or VIS. And it was a very interesting concept when it was enacted. It's been U.S. law for quite some time now. And what the law was designed to do was to create the eligibility for preferred ship mortgages for state-registered vessels. And for a state-registered vessel or a state's registered vessels to qualify for that, they had to be under a state titling system that was certified to meet federal requirements. That hasn't been done. I mean, no state, to my knowledge, has qualified. But, I mean, that's something we may see someday. Next, foreign registration can be used when offshore closing to avoid state sales tax. I mean, actually, using a foreign registry to avoid state, well, more properly, use tax, was a Florida thing. I don't know of any other state that specifically acknowledged that if a boat was under foreign flag and brought into that state with a cruising license, that it wasn't subject to use tax. But Florida, years ago, had made that determination administratively, meaning the Florida Department of Revenue decided that, well, look, to be subject to Florida use tax, the boat has to be commingled with the massive assets in the state. I mean, that's the way they referred to it. And they found that if you're a foreign flag vessel in the U.S. under a cruising license, that you're here only on a temporary basis, or the federal government in effect has found that the boat's in the U.S. on a temporary basis, and that federal finding primed any state statute to the contrary. And of course, now with the cap on sales tax in the U.S. at $18,000, or more properly, the limit on taxability being $300, which with the 6% rate, not counting any county surplus, which can be up to 1%, it'd be $18,000, and it's kind of taken all the fun out of the game. I mean, it's the idea was the way that amount was arrived at is that that's roughly what one would say it would cost to set up a foreign registry and maintain it for a few years. So the number of boats going offshore has declined. Certain boats have to. As I mentioned earlier, if you have a boat that is over 300 gross tons, you're effectively forced out of U.S. documentation, and your only choice then is to go foreign. Also, if you want to employ foreign crew, it's not that with a private yacht, a U.S. private yacht, there are citizen requirements, but they're not as stringent as one might think. For example, the master of a recreational vessel, of a U.S. recreational vessel, doesn't have to be a U.S. citizen. I mean, there's some conflict in the law on that point, but the more recent statute was to that effect, and the Coast Guard has said that they'll respect that. But the difficulties comes that, okay, I have a foreign master on a U.S. flag vessel, I come into the U.S., he may, under Coast Guard regulations, be entitled to serve as a master on that boat, but he still has to meet federal immigration requirements. And generally that's going to mean a green card, which most of them don't carry. Most foreign crew work under B1 visas, or generally issued with a B2, B1, B2, but B1 being the operative one, which, which allows a foreign crewman to work aboard a vessel that sails from a foreign port. I mean, that's the wording that's used. But the practical interpretation by CBP has been sailing from a foreign port means that you are foreign registered. That's not right as a matter of law, but what we've seen is if you have a U.S. flag vessel, even if it spends 99% of its time outside the U.S., when it comes into the U.S., CBP won't accept that it sails from a foreign port. Inversely, if you have a foreign flag vessel that sits in the U.S. for most of the year, CBP won't question or challenge whether it sails from a foreign port. It's assumed by virtue of its registry. So for practical purposes, if you want to have foreign crew with a boat that's going to be in U.S. waters, foreign registry is the only way to go. And any of the flags that are commonly used for yachts have no citizenship requirements. So you can have crew members from anywhere. Offers more privacy and higher level of service. I think what that means is, in terms of privacy, well, I should also say protection. I mean, I've had a lot of clients that are worried about traveling with a U.S. flag vessel and certain areas of the world with a foreign flag vessel, at least it's less obvious that there's a U.S. owner. It's more difficult to find out who is behind a foreign flag vessel typically, and higher level of service. I mean, the foreign registries, the ones that are commonly used, are very yacht friendly. And whereas at times I feel with the Coast Guard that we're sort of the red-haired stepchild. I mean, the Coast Guard is more about true commercial vessels than it is about yachts, not so with foreign registries. Disadvantages. Well, we've talked a bit about that earlier. First, under no circumstances can a foreign flag vessel move freely in U.S. waters. With a cruising license, you get close to it. I mean, freely, it says freely there, but perhaps it's too strong a word. Even with a cruising license, you have to report the fact of your movement to the Coast Guard to CBP when you arrive at a new location. But that's still far easier than what would otherwise be the case in terms of getting a permit to proceed. And that then relates to what we were discussing earlier in terms of the problems we've had with CBP and Fort Lauderdale and Miami in terms of refusing to issue cruising licenses as to boats that are offered for charter or sailor charter, even if the offering is restricted to non-U.S. residents. And as I think David said, I think that's wrong. We think that's wrong as a matter of law. But the local CBP station is effectively God until somebody from Washington says otherwise. And one of my concerns is that we are now pressing CBP to overturn that position in Fort Lauderdale and Miami, but if on a national level CBP says, no, they're right, then this virus is likely to spread. And I agree with what Michael Reardon said earlier, that having to get permission to proceed is not the end of the world. You just go into customs, you have to give them your registry, and you then have specific written permission to go to you go to your next port. But that can be a pain. I mean, if you're some Saturday afternoon or Sunday morning, the owner wakes up and decides, gee, I'd like to go from Newport to Nantucket. If he doesn't have permission to proceed, he can't do it. So I think it's very important that we find a way through this and hopefully get back to status quo ante, under which restricting your offering for sailor charter to non-U.S. residents would enable you to still use a cruising license. And the last point is that they are more expensive to set up and maintain. I mean, setting up, generally speaking, you set up a foreign entity to own the boat. There are some registries that accept U.S. owners, but that's not, for various reasons, that's not generally what's done. And then maintaining it annually is a higher cost than you find with U.S. documented vessels or certainly with state-titled or registered boats. So that's the quick run-through. Does anyone have any questions? Yes. Yeah, it'd be easy to hit a microphone.
On a U.S. Coast Guard registered vessel, you said no foreign crew. A skipper...
I didn't say no foreign crew. I said that it's really more a visa issue than it is a Coast Guard issue, but go ahead.
Okay. Well, let's say they don't have a green card or they're a foreign national.
Right.
I had a captain, this is the second one that recently said this, that their understanding of it was that the commanding officer of the vessel had to be a U.S. citizen, and they could have non-green card or foreign crew working for them on the U.S. Coast Guard documented boat. Is that accurate?
All right, so we're not talking about the immigration issues, we're talking about the Coast Guard issues.
Yeah, the employment on board.
The answer to that is that, as I said before, there is a statute which says that the master of a boat that carries only a recreational endorsement can be a non-citizen. Unfortunately, when they enacted that statute, they didn't repeal that portion of a prior statute which said that the master has to be a citizen. But since the statute which says he can be a non-citizen, again, only if the boat carries strictly recreational endorsement, was later in time, that the Coast Guard has been treating the earlier failure to repeal the earlier statute as just as an unintentional omission. So yeah, you can have a master, aside from the immigration concerns, on a boat that carries only a recreational endorsement as a non-citizen. But that doesn't mean that everybody else can be a non-citizen. That would be the case on a recreational boat under 200 gross tons, but if a boat is more, no, actually, well, let me take that back. There is a requirement on a U.S. flag vessel that the engineer, someone doing engineering or navigational watch, and your radio officer, things that may or may not apply, are to be citizens as well. So there is a citizenship requirement beyond that just of the master. But the other thing I was going to say is that when you get boats that are over 200 gross tons, something called the Officers Competency Act kicks in. And with a boat over 200 gross tons, you have to carry a license. Certain positions have to carry Coast Guard license, whether the boat's being used privately or commercially. And so even the master, under those circumstances, would have to carry a U.S. license, private yacht over 200 gross tons, which aren't available to foreign citizens. So they get you that way. But going back to the first question, if it's a recreational boat only, under 200 gross tons, you can have a non-citizen master. Again, you have the immigration issues within the U.S.
Question in the middle, back here, Nicole.
If you have a U.S.-built, foreign-flagged yacht that's been denied a cruising permit and has a bareboat agreement in place, is the captain able to go and ask for a right to proceed or permission to proceed?
Yeah, you should be.
In Fort Lauderdale, or is Fort Lauderdale going to automatically say, are you under charter?
The short answer to your question is I have no idea what Fort Lauderdale might do. But technically speaking, the cruising license is independent of your right to conduct a bareboat charter. I mean, that depends on whether the charter is truly bareboat, not just.
It is.
All right.
So
and the other issue being that if it's to a U.S. resident, the boat would have to be duty paid. The cruising license permit to proceed issue is independent of that question.
So if your bareboat agreement was with a U.S. resident, the captain would be able to go without, in his mind, lying and say, I would like permission to proceed for this trip from Fort Lauderdale to Ocean Reef.
For permission to proceed. Of course, again, if it's a U.S. resident charter, the boat would have to be duty paid. But I was serious earlier. I'm not going to predict what Fort Lauderdale CBP would do under those circumstances.
Okay.
I mean, they've already interpreted the law in a way that I don't think is correct. So we'll have to see what they do next.
We have time for one more question. We are running a little bit low.
Rob, did I understand you correctly when you were in the beginning, when you were talking about Florida titled vessels owned by foreign people, that Customs is treating them the same way as foreign flag vessels altogether?
Yes and no.
So basically what you're saying
let me go through it one more time because it's a little complicated. What they have determined or said in the past, that if you have a Florida titled boat and it's owned by a non-citizen, that it is a foreign vessel. On the other hand, since it's Florida titled and not under a foreign flag, it doesn't qualify for issuance of a cruising license. and therefore to move the boat from point to point would require permission to proceed. Now, this has only come up in my career a couple of times, and in each case it was because the boat got stopped and questioned, and the facts came out. I mean, there's a lot of boats traveling up and down the coast that are owned by foreign citizens, I mean, Canadians, Mexicans, et cetera, but technically, if they got stopped, CBP could take the same position.
Rob, thanks so much.
Okay?